Thanks very much, Lindsay. My name is Chris Bell, and I was one of the disabled lawyers that worked on drafting the ADA many years ago. And I'm now a board member of the American Council of the Blind. Well, I think it's very important to focus on a couple of things Lindsay said. And one of them is that only 10% of the municipalities within her region that she surveyed had ADA transition plans. And the significance of that is simply this. If you don't have a good self-evaluation, which has gone through and identified your physical barriers and made a plan to have them removed and have an accountable person and a budget, you haven't done all of that, you're probably looking at an accessible public rights of way that isn't accessible. I mean, one of the problems we have from an accessibility compliance standpoint is we don't have final public rights of way accessibility guidelines. These were to be issued by the US Access Board, and they were approved in March. However, the Office of Management and Budget did not clear them and asked for changes. So we don't have the final version of the guidelines. We're also waiting for the 11th edition of the Federal Highway Administration's Manual on Uniform Traffic Control Devices, which will affect some aspects of accessibility, as I'll discuss in a little while. So typically in many cities, what people with disabilities find is that there are missing curb ramps, or that curb ramps are broken, or that their slope is too steep, or they end in a pothole. There's one in Minneapolis where I used to live that the landing at the top went right into a huge utility pole, obviously not very useful. And so one of the problems is, therefore, that there's a lot of non-compliance out there. So one of the things that's important to do when you are doing a self-evaluation is to involve people with disabilities in your self-evaluation. Because the truth is, people that don't have a disability aren't necessarily going to be able to see what's wrong. I can't speak as a blind person from the Google view that Lindsay was showing, but I can tell you that there are things about accessibility that you won't see. For example, in Minneapolis, the local public works director decided it would be very scenic to make a sidewalk up with cobblestones. And they did that. Well, one of my friends who's a wheelchair user dragged this person out and sat him down in her wheelchair and said, okay, push yourself along this street. And he discovered, to his horror, that his teeth chattered as he was going up and down, up and down, up and down all these cobblestones. And his immediate reaction was, I will never use cobblestones on a sidewalk again. So visually, it didn't seem to be a problem, but actually it was a problem. But you have to involve people with disabilities in your self-evaluation if you're going to be able to spot those problems. And if you don't do that, you're going to miss a lot of things. Now, so one of the problems with the fact that so few municipalities have done self-evaluations and transition plans is that we have a lot of non-compliance. And as a result of that non-compliance, we've had a lot of litigation. Back in 2014, there was a settlement of a lawsuit brought against the California Department of Transportation. They had thousands of miles of sidewalks, and they were ordered to make those sidewalks and their curb ramps, many of which were missing and broken up, accessible. And it was going to cost them $1.1 billion. So this is serious liability. Another aspect to the liability, of course, is that if the plaintiff, usually wheelchair users, file suit, you know you have a problem. I mean, they're not making it up. And their lawyer is not filing a class action just to get news, right? So if you're going to lose, you're going to end up paying for not only your own city's attorney's fees, but also for the attorney's fees and costs for the plaintiffs. So for example, a group named Liberty Resources filed suit against the city of Philadelphia for their inaccessible sidewalks and curb ramps. And the city had to pay $1.1 million in attorney's fees and costs for the plaintiff. Now, maybe you're big enough so that $1.1 million doesn't make a big hit on your budget, but I bet it doesn't help your standing with your superiors about it. There have been a lot of other suits in San Juan, Puerto Rico. Their situation was so bad. In fact, they had cars parked on sidewalks. They had utility poles on sidewalks. They had missing curb ramps. They had cracked streets. And it was so bad that, in fact, not only did wheelchair users sue, but the United States of America intervened through the Department of Justice to take the side of the plaintiffs against San Juan. Obviously, that was going to be a lot of litigation. By the way, when the Department of Justice sues you, the folks they use for their investigators is the Federal Bureau of Investigation. It's always nice to have the FBI on your side when you're doing litigation. So then we have in Baltimore, there was a group of wheelchair users filed a class action against the city. And here's an example where it must be that Baltimore did not make their sidewalks accessible initially, because they had 37,000 curb ramps and only 1.8% of them complied with the Americans with Disabilities Act accessibility guidelines. So obviously they had a lot of work to do to settle that case. And then there's New York. So New York was subject to two separate suits for their failure to have accessible sidewalks and accessible curb ramps. And they settled in 2019 and were obligated to make hundreds of millions of dollars versus repairs. And that leads me to my next point, which is there's another aspect of accessibility that has not gotten much news, and that is accessibility for my community, for blind people. And the problem basically is this. You've all seen pedestrian signals, right? So they have the walking man when you can walk, and the sign, hand that's raised that says, don't walk. Well, if you're blind, those signals don't exist. And if you're blind, what that means is you have to listen to the traffic flow to figure out when it's safe to cross. And this is not necessarily easy to do with background noise, with quiet cars, with quiet e-bikes and bicycles. And so it's a dangerous prospect. If you doubt that, try it sometime. Get a orientation mobility person to help you learn how to use a white cane and cross the street with a blindfold, and you'll discover that it's somewhat nervous making. So the American Council of the Blind chapters started out by suing New York City. And New York City had only a very small percentage of their pedestrian signals equipped with what are called accessible pedestrian signals. And an accessible pedestrian signal is a signal that, as it sounds, you have a tone that's going off so a blind person can know that there is an accessible signal there, they can find it, and press a button. When they press the button, if the walk sign isn't lit, it'll say, don't walk sign is on. And when the walk sign comes on, you get this rapid ticking sound, which tells a blind person that the walk sign is on. They still have to listen to make sure they're not walking out in front of a car, but they can tell when to cross. And that button that they push also has a physical arrow, a vibrotactile arrow for people who are deafblind, and it vibrates so they know that they can walk and in what direction. So this is a very important aspect of accessibility. However, they're not frequently installed in many places, and they were not in New York. So suit was filed, and the ACB New York affiliate got the court to agree that the failure to have accessible pedestrian signals was a violation of Title II of the ADA and of Section 504. And subsequently, the court issued a final order directing New York City to install 10,000 accessible pedestrian signals a year so that in 15 years, all of their pedestrian signalized intersections would be completely accessible. Now, and sorry, Lindsay, I hate to do this, but now we move on to Chicago. And the American Council of the Blind Metropolitan Chicago chapter sued the city of Chicago for the same problem, inadequate number of accessible pedestrian signals. And actually, Chicago, according to the United States, was the worst offender. They only had 0.5% of all their pedestrian signals accessible. And that's another case in which the United States, through the Department of Justice, intervened in the litigation on behalf of the blindness community. And like the court in New York, Chicago was found to have violated ADA Title II and Section 504 for its failure to have meaningful access to its pedestrian signalized environment. That case has not gone as far yet as New York. Their next step will be to do a remedial hearing where the parties with the court will figure out exactly how the city will go about installing the accessible pedestrian signals. So that hasn't happened yet, but it will happen, and it will cost Chicago a lot of money, as well as attorney's fees. By the way, when the Department of Justice sued Chicago, they asked for damages as well as for relief to make the signals accessible. And they can go back 2 years. We don't know what the damages are that they'll ask for, but Chicago will pay attorney's fees for the plaintiffs, court costs, and some amount of damages for the United States of America. So accessible pedestrian signals are a new piece on the future of accessibility. And I can tell you that there's one other major city that ACB is about to file in for failure to provide accessible pedestrian signals. So it's something that ACB is pursuing with a lot of vigor. So there are a couple of other things that I think you may see in the future about accessibility. And one is snow. There was a lot of snow in the northern part of the United States last year. Buffalo got creamed with lake effect snow. And so did Minneapolis. I think Minneapolis got about 7 feet. So Minneapolis on its own has decided to undertake snow removal on sidewalks, which previously had been the responsibility of business owners and residents with adjacent sidewalks. I think you're going to see litigation under the ADA for the failure of municipal governments to remove snow and ice on sidewalks, because it's just not realistic for residents and business owners to do it. That's one thing. And secondly, if you have a foot of snow on your curb ramp and on your sidewalk, nobody with a disability is going to be able to use that facility. And that facility is as inaccessible as it would be if there wasn't a sidewalk or weren't curb ramp. So I think that is the next area of litigation. So thank you for allowing me to share some time with you. And I will now turn you over to Mr. Greg Martinez. Greg, take it away.